Good afternoon. My name is Les Gold. I'm a partner at the law firm of Mitchell, Silverberg and Knupp. Our firm does a great deal of work in the security alarm industry and a great deal of work in mergers and acquisitions in the security alarm industry. In the past few years, many new issues have arisen in dealing with mergers and acquisition transactions, which we would like to discuss today. Joining me this afternoon will be two of my partners, Tony Adler and Sue Ross, who have dealt with many hundreds of mergers and acquisition transactions over the years. We've constructed a scenario which some of you may recognize and which I'll read to introduce each of the sections. The three of us will discuss new issues and how we should deal with them to eliminate any potential liability. We hope this presentation will be interactive, so if you have any questions, feel free to submit them. Sue, the topics which we will discuss today are COVID-19 vaccinations, surveillance tapes and law enforcement, facial recognition, cybersecurity, and independent contractors versus employees. With the first scenario, Ilse Lund, who is the CEO of Acme Alarm Company, had just gotten home from another long day at the office. Settling into her favorite chair in the den with a pre-dinner cocktail, she was looking forward to a quiet dinner at home with her husband, Victor Laszlo, the chef owner of Frere Gomez, a French-Mexican fusion restaurant, who had taken the night off to cook dinner for Lisa. Just as she started to relax, her cell phone beeped. It was an email from Signor Sig Ferrari, Acme CFO, with due diligence report on Rick's Alarm and Guard Service, Inc., also known as RAGS, owned by her old Harvard Business School classmate, Rick Blaine. 2 weeks earlier, Acme signed a letter of intent, an LOI, to acquire RAGS in a $25 million stock deal. In the cover email, Sig advised, while everything for the most part was in order, there were a few items that he thought should be run by Acme's outside counsel. Sue, as co-outside counsel, how does this affect the potential acquisition?
Well, so let's start with, none of us are labor lawyers, but since I co-chair the firm's virus reopen practice, we thought we would start with the topic that's on everybody's list, which is the COVID-19 and the vaccinations and what you can and can't do. And by the way, if you listened carefully to what Les was reading off and describing, you hopefully come to the conclusion that we're all fans of Casablanca. That aside, so the first thing that came up in Rick's email was that there's a COVID-19, the vaccine supplies are plentiful. RAGS has offices in various locations where the vaccine is available. It's mandating that all of its employees be vaccinated unless they provide a letter from their primary physician advising against being vaccinated because of a specific medical condition. And then goes so far as to say those employees who fail to be fully vaccinated within 90 days of receiving notice will be terminated. For these purposes, RAGS considers both employees and contractors to be subject to the same rules and does not draw a distinction between them, at least as related to the vaccine requirement. So the reason we said we're not labor lawyers is because a lot of the issues that are still in place have to do with what you can and can't do with employees. And the point to start with is that any existing accommodation rules at the federal or state level remain in place. One of the unique quirks, if you will, with the vaccines is that they were approved by way of the FDA's Emergency Use Authorization, or EUA procedure, which means that they are not considered to have gone through the usual vetting process, which makes them an unapproved drug. So the law is unsettled as to how far you can go in disciplining an employee who doesn't want to come back to work and who won't get vaccinated. The right to terminate is the part that's the open question. The right to discipline, the right to accommodate by allowing them to work from home and so on, which might be plausible given depending on your operation, that seems to be pretty well settled. The fact that regs is not differentiating between employees and contractors is the other point that's worth discussing, because employees are subject to one set of rules, which of course are all the labor rules within the states. But contractors, and Tony's going to talk a little bit more about the distinction between them later on. Contractors, of course, work subject to a contract, and typically you can put different restrictions on them or different rules on them. The other point worth making before we move on to other topics is, under the Americans with Disabilities Act, any information an employer has that is got to do with their employees' medical information must remain confidential, unless the employee agrees otherwise. And so this is raising some questions about, if you insist that employees be vaccinated, how do you go about granting them, for example, the ability not to wear a mask, which is now permitted? How do you go about distinguishing them in a legitimate way between those that are vaccinated and not vaccinated, so that neither side or the other feels as though they're being discriminated against? One of the frustrations with this whole process, of course, whether it was the rules to close down, whether it was the rules to reopen, and certainly the rules having to do with employment, these are all really being determined at the state level for the most part, certainly except for the employment area, where obviously some federal law applies. And so what we've begun to see is, I think there's 3 total cases that have been filed now having to do with, if the employees refuse to become vaccinated, can you terminate them? The first one was decided as we're taping about a week ago, and had to do with the Houston hospital, where the judge entered an order stating that because of what is in Texas employment law, and the fact that the refusal to vaccinate was not something that was a criminal act, therefore the hospital could require vaccination, and the choice of the employees to be vaccinated or not was theirs, understanding that if they refused, they would be terminated. So this continues to be an area where things are changing, but is probably right now the hottest topic. And so if you're looking at an M&A transaction, the question becomes, obviously, what has the company done? How has it treated its employees? Are there potential areas of exposure having to do with the employment angle of it, having to do with the confidentiality question presented by the ADA and similar provisions? And I'm going to hand it off.
I don't mean to interrupt you, but
Go ahead.
Acme's making an acquisition. What is their potential exposure here if they take over the company with these labor issues?
Well, if they find that the labor issues have not been dealt with correctly, then it becomes a question of, can they solve them? Can they correct the mistakes that were made? And alternatively, if they don't discover them, then of course the issue becomes theirs to deal with down the road. And the other point to make, of course, would be, in the M&A transaction, are these the kinds of violations, breaches, whatever you want to call it, where they could be left to the original owners versus being assumed by the new owners? And
that would be a function of how they negotiated the deal, because this is
right.
A stock transaction, and in a stock transaction, the buyer assumes essentially the liabilities that the target company had. Those can be negotiated away through the M&A process, but at the end of the day, it's going to be the buyer's problem unless it's shifted to the seller. One quick question about the Houston case, Sue. Do you think it makes a difference that involved a hospital and a healthcare institution, where obviously concerns about spreading disease is paramount, and perhaps in the context of other businesses, including a security alarm business, the necessity to have a healthful environment as possible may be less critical in a non-healthcare setting?
Well, Tony, interestingly enough, although the court did discuss the fact that it was a hospital, and obviously the benefit to be drawn from the fact that everyone would be vaccinated and the ability to provide the medical services that the hospital would provide were discussed. And I think they were discussed simply to make the point that the vaccination requirement was reasonable. But the way I read the decision, I don't think it turns on that at all. I think it turns on the fact that of how Texas employment law is listed, and the limitations in terms of what the employee's rights might be, not specifically in this context, but sort of generally. In other words, there are only a limited number of circumstances in which an employee is permitted to refuse to comply with what would otherwise be a lawful directive from their employer.
Bottom line, it seems to me, though, that this is really perhaps one of the first times in our history that we really had to be concerned about these medical issues in dealing with an M&A transaction. Is that a fair statement?
I think that's absolutely correct. And that's why we started with this issue. This has just become a headache for everybody on a lot of different levels.
All right. Well, let's move on then, because we have other issues. The Gotham Police Department, in which RAGS has a large number of both commercial and residential customers, has on multiple occasions requested copies of the video feeds from both commercial and residential customers when investigating crimes which the police may believe may have been captured on video. RAG's protocol for these requests is to ask permission of the owner whose property has the video cameras. Although in some instances, because of what are described as exigent circumstances, RAGS has been unable to contact the customers in a timely manner, and desirous of maintaining a good working relationship with Gotham's police, Lou Renaud, RAGS has given, police chief, by the way, Lou Renaud, RAGS has given the police access to the relevant footage without the customer approval. Tony, as co-counsel, how does ACME deal with these issues in an M&A transaction?
Next slide, Sue.
Sorry.
So the first thing to keep in mind is that currently, at least, there's no federal or state law that expressly prohibits the sharing of surveillance tapes with law enforcement. Unless the contract between the alarm company and the customer, or the terms of use that the alarm company sets forth, provides to the contrary, the consensus is that the surveillance tapes likely belong to the customer because it's the customer's equipment, whether they own it or they're leasing it from the alarm company that recorded the images. From the perspective of the alarm company, the best practices for the customer contract and or the terms of use, whichever the alarm company uses, state clearly that the alarm company may share the surveillance tapes with law enforcement and other authorities without seeking the consent of the customer in each case. It's our understanding that the two most prominent surveillance systems currently available, Ring and Nest, do provide in their terms of use that they do have the right unilaterally to turn over surveillance tapes to what they view are appropriate government authorities under appropriate circumstances. Next slide, please. From the standpoint of our hypothetical transaction and what ACME should be doing from a due diligence standpoint, certainly it needs to, number one, review carefully RAG's terms of use or customer contracts on this issue to determine what it is that RAGS is allowed to do. That would be the first step. And then the next step would be to interview the key people at RAGS to determine what they're actually doing. A significant potential problem is if the terms of use of the customer contract say one thing and in practice the alarm company is doing something else. So for example, if the contract or the terms of use states that RAGs will only share surveillance tapes with police or other law enforcement organizations with the prior consent of the customer whose camera was used to capture the images. And if in fact RAGs does not do that, they run a risk of potentially significant liability from an unhappy customer. And as we've learned in other areas of the security alarm industry, an individual lawsuit for this type of a violation might not be considered a big deal, but the real concern is that an aggressive plaintiff's counsel could bring a class action lawsuit on behalf of all customers.
Tony, let me interrupt you for a second. In your opinion, would this be a sufficient concern on behalf of these to terminate the transaction?
At this point, I don't think I would go that far. Again, I'm not aware of any case law that's developed. It's more of a potential liability. What may be a bigger concern, and again, it would take some analysis of what jurisdictions the problems arose in, but the other potential concern is local district attorneys or a state attorney general, or even possibly a federal agency, upon receiving complaints from customers that the alarm company in this area is not following its terms of use or customer contracts, could bring an enforcement action against the alarm company. And as we've seen in other areas, that can get very expensive, both in terms of the legal fees in defending RAGs, as well as the potential fines. So something that certainly they need to look at carefully. And the other thing to keep in mind, the final thought on this topic, is that this is clearly an evolving area of the law, and many civil liberties proponents and Fourth Amendment rights proponents are quite concerned about the implications of surveillance tapes that capture images that go beyond the customer's premises. And I think we should not expect that the law is going to be static in this area, and that in fact in future years we may see more legislative solutions to this this problem.
Well,
So Tony, I want to, sorry, go ahead, Les.
Well, can a buyer really protect themselves against this potential, class action or what have you? I mean,
well, again, the only effective way of, if they're doing a stock deal, is by way of negotiating with the seller the shifting of the potential risk to the seller away from the buyer. But as everyone who works in the area knows, having negotiated that, it's only as good as the ability and willingness of the seller at the end of the day to honor its indemnification obligations. It's not certainly a perfect solution, but it's one that certainly a buyer should consider in moving forward with this area. In this area, again, I wouldn't typically view this problem as so fundamental that I would advise a client not to move forward with the deal, but it's certainly something that's going to require their attention to detail going forward.
So Tony, let me give you a what if. We said that there were requests. We set up a hypothetical and we said there was a request for the information. We didn't specify how the request was made. Would you agree with me that if there were, for example, at least a written request or a subpoena for the records that was honored, that would likely give you a different level of comfort than if it was simply some, police officer made a phone call and they turned the records over?
Sure, because I think at the end of the day, if the alarm company is compelled by legal process to turn over the tapes, I think that would insulate them from liability in most cases, even where turning over the tapes was inconsistent with or in violation of their terms of use or terms in their contract. Again, hopefully there's a provision in the terms of use or the contract that would deal with that possibility, not only in the context of this particular topic, but in general, where it wouldn't be considered a breach if the alarm company does something mandated by law that's technically inconsistent with the terms.
Okay, we had better move on here. RAGS has been asked to beta test a line of facial recognition access control devices, which H. Strasser and Daughters, Inc., a prominent access control device manufacturer, has developed. Question here is, what are the issues with facial recognition? Well, I think the buyer first has to determine, is the company actually installing a biometric system? If yes, where is the system installed? And has the state or local government enacted any laws or regulations on this topic? And this becomes very, very important because many companies have installed, particularly facial recognition. Now there's fingerprint and so on, but that has not raised an issue. Facial recognition has, in many states as well as the federal government, have actually now passed some legislation or are thinking about legislation. We've listed them, the states that we're familiar with here and the cities. And I might just add that this week, the city of Baltimore, the city council passed a facial recognition ban prohibiting law enforcement and municipalities from procuring or using facial recognition technology. The ban also bars private citizens from leveraging its purchase and use. Now, not 100% sure of what that means, but they are limiting its use by businesses. Portland, Oregon has sought to ban private use of the technology by all businesses. Now, this is not passed, but it's before the city council. Federal government is also considering passing some legislation involving facial recognition technology. So I might add that certainly a buyer has to be very, very sensitive to this issue. And if in fact facial technology is being installed by a company, then they should really determine where the company is located and determine whether or not they're in violation of any of these ordinances or state laws. It becomes very, very important.
So Les, we know from conversations we've had with some of our clients that some of them have been using facial recognition. And I'm thinking particularly, for example, with banks where they've got multiple branches in a small geographic region, and they're seeing people that are coming into different branches at different points in time. So if you already have the service in an area where there's a new law passing, I think it's particularly important to see exactly what's in that new law and whether you're grandfathered in or whether there's some other adjustment you have to make to the service to be in compliance.
Well, when you go to Europe, their facial technology, facial recognition technology is really accepted. And if you go to airports and so on, it's been accepted. It's the real issue is how is it going to affect private businesses who are providing this service as opposed to, public agencies. So I think it becomes very, very important for ILSA to make sure that they are, that if in fact RAGS is installing facial technology, whether or not it's approved, where the states were and the municipalities where it has been installed.
Les, so do you think it makes a difference whether they're using the facial recognition technology as a access control system, or they're using, in the case of what you suggested, Sue, where a bank has surveillance cameras, which have been around for 20, 30 years, maybe longer, using it to, if there is an incident, using it to potentially identify somebody that was in the tape.
Well, that's a good question, Tony, and that goes to Sue's point. It really becomes a question of whether it's being used for, what it's being used for, and that becomes very, very important. And just to give you an example, in Baltimore, they have an exclusion where it's being, it's included in part of a system. But I'm not in a position to tell you exactly what it was. I haven't looked into it yet. That just passed this week. But it's a good question, and it becomes very, very important.
I think your point is well taken, Tony. If you're using it on a limited number of people as an access control, the discussion is quite different, because we know from everything we've read and seen that the concern about facial recognition is it's discriminatory, or what are perceived to be discriminatory potential applications. The false positives, the false negatives you get for anybody that's not Caucasian.
So perhaps it's a question of what they're going to use the recognition technology for, as opposed to the technology itself.
Right. Okay, moving on here. RAGS, their head of cybersecurity, Tom Polthouse, has just informed Rick that RAG's computer system on which it stores customer information, including security passcodes, as well as names, addresses, and other contact information, may have been hacked by the Maltese Falcon Group, a well-known cyber extortion gang, as Tom has received a communication from Ruth Wonderly, MFG's chief spokesperson, who is demanding 100 Bitcoins within 48 hours, or MFG will publish on the darknet all of RAG's customer information. The IT security firm hired by RAGS does not believe any of the data stored on the servers has been compromised. As yet, RAGS has not formulated an action plan for dealing with this possible data breach, although it is looking into how it acquires Bitcoins. Sue, how can Acme Alarm deal with this if there is an acquisition?
So let's sort of set the table a little bit. When I first started dealing with cybersecurity, it was cybersecurity. Now it's really more a privacy issue. And although we have not used that term until now, when Tony talked about the terms of use or the terms of service, we certainly intended that to include the privacy policy. The topic of ransomware, which is what we're talking about today, has spread remarkably. And when I started with cybersecurity in the early 2000s, if you were hacked, you could usually restore the information from your backup, and there was honor amongst thieves. Now, the process, as most people know, is that they not only get into your system, they get into your backups, and you don't really have the ability to restore. So we're seeing with the Colonial Pipeline case, for example, the recent questioning on the part of Congress about why they spent $11 million in paying a ransom. So understanding first and foremost what happened and where it went is the key. And in this case, really what's striking is that there was no response plan in place. Most companies have a physical security program, and some have expanded to a data security program or a privacy program. But there really does need to be a program in place, and unless you hit on something that's worth mentioning here, and that is, when we talk about Europe, the idea is that everything is private until the individual agrees to make it public. In the US, it's the other way around. It's everything is public unless we can figure out a way to make it private. So when it comes to dealing with all of this, the first question is, can you identify who it is that's conducting the ransomware attack? And we made a note here about the possible OFAC consequences. OFAC is the Office of Foreign Assets Control. It is the part of the Department of Treasury that deals with all of the economic sanctions programs that the US has. And more what we're finding is that the individuals that are engaging in these ransomware attacks are actually listed by OFAC as parties with whom you're denied being able to work, being able to conduct business, and therefore being able to pay them a ransomware. The topic of cybersecurity is a very interesting one from the perspective that I do a lot of work dealing with government agencies at various levels. And my general attitude is, I don't want them anywhere near what's going on. This is the one area where that is the exception. If you are hacked in any way and you think it could in the least bit be serious, you want to call either the FBI or the Secret Service. They both work together. And if you cooperate with one of those agencies, they will let OFAC know, and that goes a long way towards mitigating any penalty that might be imposed for having paid the ransom to a party that is denied the ability to do business with anybody in the US. The second thing would be to look at what the terms of use and privacy policy are, to understand, we said name, address, other contact information. That is what is generally understood to be, along with email addresses, phone numbers, and then sort of the more sensitive driver's license, social security numbers, et cetera, credit card information. That's all understood to be personally identifiable information. So making sure that you've got the right kind of language in the terms of use, the right kind of language in the privacy policy, and looking at what's in there. And again, what are they saying they're doing? What are they actually doing? And how far off is that? Everybody knows about the GDPR in Europe, actually in what they call the European Economic Area, because it extends beyond just the European Union and now also includes the UK. But we also generally know about the California Privacy Act, but we've just got Virginia enacted one about 6 months ago that takes effect in 2023, I think it is, and January 2023, and then Colorado in the last couple of weeks enacted its own privacy law, which takes effect in July of 2023. So understanding not only what's in the terms of use, what's in the privacy policy, what are being done, but where are your customers, or in this case, where are RAG's customers, and are there privacy laws that exist there? Now, I want to do a sidestep for 2 seconds, which is, let's be clear that there's a difference between we were hacked, your data was, as they call it politely, exfiltrated, in other words, put on the dark web, and therefore you have an obligation to notify consumers, which is pretty much the standard in every state, versus additional privacy laws like in California and in the near future in Virginia and Colorado. So the first issue would be, as I've said, figure out who's making the claim, are they on an OFAC list? And also, what was the company saying it was doing? What did it actually do? And is there exposure for that, coupled with, is there exposure under California, Virginia, Colorado, or any other local laws which might apply?
Sue, wouldn't one issue for ACME to consider in terms of its due diligence is to certainly find out whether RAGS is using best practices? In other words, does it really need, from a customer relations standpoint, a customer social security number? It seems to me that that's probably not the case. And so it shouldn't be collecting information it doesn't really need that's super sensitive.
No, I totally agree with you, Tony. And if we had more time, we could go into a whole bunch of things, starting with one of the first things we saw with our clients that do business in California that are subject to the CCPA, or the California Consumer Privacy Act, was they did a survey of, what's the data we collect? What do we really need? How long do we keep it? And if we say we're going to keep it longer, do we have a good reason for it? And so, yeah, you'd want to know that. And the other thing we shouldn't lose sight of is we know that RAG's team doesn't think anything's been compromised. But, do they have insurance? What did they tell their insurance company they were doing? And is that their current practice? Do we have our own experts that we want to have take a look at things to make sure that we're satisfied there is or isn't a breach? Because if there is a breach, obviously, Tony, you've made the point several times, it becomes the buyer's headache, but is there a reserve that can be set? How do we negotiate all of that? So there's a number of other issues that would come to the fore in terms of making sure that we cover the basics.
This is probably more a question for Tony, but can due diligence really uncover these privacy, these privacy issues and the cybersecurity
Well,
issues.
it can certainly uncover what it is RAGS does, and as to Sue's point, what information are they collecting it? Do they really need it? I think as part of an audit, they would go through that exercise, and at least moving forward, if they do the acquisition, and if they've concluded that RAGS is collecting sensitive information it doesn't need, they can stop the practice.
Yeah, and to answer your question, Les, I think realistically, it doesn't take that long to figure out that there's a problem. You know, the way the guys that we work with usually operate is they mirror the servers, and they have ways that they can parse down the data they need to look at. They can look at the logs and fairly quickly at least make a preliminary determination that they think there is or isn't a bigger problem.
Okay, I think we're getting down towards our time limit here, so I'd like to move on to the last segment. RAGS has full-time installers who are treated as employees, but also relies on a number of technicians which RAGS periodically engages to handle emergency service calls or alarm system installations when the backlog of installation and service calls becomes too much for the full-time installers to handle. Those technicians are treated as independent contractors. SIG believes that should probably be fine since these technicians provide similar services for other alarm companies and supply their own tools and drive their own automobiles or trucks when on service and installation calls. Tony, that's become a major issue today. To what effect is the employee subcontractor issue going to affect a potential acquisition of this company by Acme?
Yeah, let me take things a little bit out of order here. Let me first talk about what the consequences are to RAGS and ultimately to Acme if they do the deal and RAGS has gotten it wrong. And what I mean by getting it wrong is they've misclassified independent contractors who really should be treated as employees. There's probably little liability if it's the other way around. If they've been treating people as employees that could have been treated as independent contractors, but that would be the rare circumstance. The real problem is individual workers who were treated as independent contractors, but really were employees. And what's the consequence? Well, number one, because they were incorrectly treated as independent contractors, there will no doubt be payroll tax, including income tax withholdings that should have been paid over to the government that weren't paid over to the government. In addition, there may be additional labor law violations in terms of not paying workers overtime where they were entitled to it, that potentially create huge liabilities. Again, as I talked about earlier on the surveillance tape topic, there's always the potential when there's been labor law violations of a class action lawsuit, a serious problem for any company in any industry that has more than just a handful of employees. So this can be a very high dollar issue. And I have seen this issue, if not kill a deal, make it much more difficult to get done, much more difficult to negotiate. So the fundamental question is, are these technicians independent contractors, or are they employees that have been misclassified? And Sue, if you could go back to the prior slide, the prior two slides, the traditional test is what is called a right to control test. And the most important factor is, does the hiring entity have the right to direct the control and control the manner and means of performing the work by the worker? That's really the key test. There are a total of 9 other factors that courts look at. I've listed only 4 here: the ability to discharge at will, whether the workers engage in a distinct occupation or business, method of payment, whether the parties believe they have created the employer-employee relationship. The court will look at each of these factors and weigh them. And again, the most important one historically has been, does the employing entity or the hiring entity have the ability to direct and control the manner and means of performing the work? If it does, and if a number of the other factors would tilt towards the workers being employees, then it's likely that that's where the court's going to come out. Some other jurisdictions, including in particular California, have recently streamlined this 10-factor test and have created something called the ABC test. And Sue, if you could turn to that slide. And there, the number of tests has been boiled down to 3. The first is that the worker is free from the control and direction of the hiring entity in connection with performance of the work, both under contract for the performance of the work and in fact. So if the contract says that the independent contractor, the worker, is free of control and direction from the hiring entity, that's obviously a good fact. But if in reality that's not how the relationship's been working, then that prong of the 3-prong test most likely will be found by a court to have been failed. The second prong, the B prong, that the worker performs work that is outside the usual course of the hiring entity business. Now, in our hypothetical, we've been told that RAGS has installers that are on the payroll, but it also uses outside installers. So I think in the case of our hypothetical, the factor B will not have been passed because, in fact, RAGS does have workers on the payroll who do exactly the same thing that the ostensible independent contractors are doing. And finally, the third test, the C test, is the workers customarily engage in an independent established trade, occupation, or business of the same nature of the work performed. This may be a little bit easier for RAGS to satisfy because, again, in our hypothetical, we know that the independent contractors or the technicians they treat as such are free to, and in many cases, will work for other alarm companies doing the same thing. What's important to keep in mind in this alternative test is to pass it, the hiring entity must pass all 3 prongs. If one of the prongs isn't passed, then under this alternative test, the subject worker or workers will be considered employees and not independent contractors.
Thank you. We have, I think, about 2 more minutes, so I would like to just take maybe 1 minute each. Should Acme buy RAGS?
Well, Tony's usually more conservative than I am, but I think my answer would be, at this point, there's some more information I would want. I think the issues that we're seeing or we talked about today, and we intentionally didn't cover the intellectual property rights that was in the title because, frankly, there's nothing new there that was more important than what we covered. I think with a bit more due diligence, I might feel much more comfortable with this transaction, specifically in the cybersecurity area. But Tony, what do you think?
Well, I would certainly agree with you that I would like to get more information, but notwithstanding my conservatism in perhaps other areas of life, the problems that we've identified are, I think, frankly, problems that many companies face. and they may face not all of them, but it wouldn't be surprising if they do. So I would be of the view that unless we come across something that in one of these areas is going to be a huge liability, and if we haven't an alternative to how we can shift this or share the risk with the seller, I would be inclined to, on the assumption that we can do that, I would be inclined to move forward with the deal. You know, at the end of the day, business always involves risk taking, and it's never going to be possible in any deal to eliminate them all. And
Yeah, I agree with that.
Nature of the beast, if you will.
Is it fair to say then in dealing with an M&A agreement today, it's a little bit more complex because of the issues that we've raised here today? Is that a fair statement?
Yeah, I mean, it's in my view, you know, 10 years ago, we didn't have the same issues. We may have had the independent contractor versus employee issue, although it wasn't as dominant an issue as it can be in current deals. And certainly we didn't have the cybersecurity and surveillance issues that we've talked about today. So, yeah.
Okay.
Yeah,
well,
but I think you're right, Les. I think it's all about just understanding that things have gotten more complex and feeling comfortable with things, from understanding what the legal requirements are, and then the business people making the decision that the risk that they're going to take is something they're willing to tolerate.
if I may just close, and I'll use a little bit of prerogative here, being on the as a vice president of SIA, with reference to facial recognition, SIA has really taken the lead in trying to deal with communities, policing agencies, and the general public, in trying to develop standards so that we can get rules, regulations on facial recognition, which will be agreeable to everyone and eliminate a great deal of the problem that's going on today. And then that, I think we can close it up, and we thank everyone for listening. Thank you, Sue. Thank you, Tony.
Thank you.
Thanks, Les.